Relevant to these functions and duties of the board, the district and to the district is something shocking that Fishback Dominic learned recently about what Disney and the district were doing in January and February of this year before the new Enabling Act became law and before this board took office. In order to get background information, we've been tasked as special counsel for less than 3 weeks, or about 3 weeks now. We've been receiving various agreements from the district, agreements that the district entered into. On Friday, March 17th, at night, around 8:30 at night, Mr. Arterman and I received an email from the district containing 4 agreements, one of which was a development agreement that was dated February 8th, 2023, just 3 weeks before the adoption, or before the signature of the governor on the new Enabling Act.
19 days exactly.
And that development agreement is between Disney and the district. On Saturday morning, March 18th, I started glancing through that development agreement, which is attached to that email. And when I opened it up and started scanning through that development agreement, I could tell right away that this development agreement is a highly unusual document, and the timing of it is very suspect. You know from my bio and Kurt's bio that we represent a number of jurisdictions with land use authority, and we have a lot of experience dealing with development agreements. I felt it was very important to get this board this document right away so you're aware of it. So I sent it to you via email on Saturday morning. Later that day, same day on Saturday, I was going through the agenda of February 8th of the prior board to get some context about that agreement, and I found another document that's just as shocking and abnormal, which is a set of restricted covenants that the district signed in favor of Disney. So I thought it was important that this board get a copy of that right away, so I emailed it out to you all on Saturday afternoon. And I'm going to outline for you why these are unusual documents and the problems that I have just spotted with them initially, and I think it warrants additional investigation and evaluation. First of all, what is a development agreement? There's a statute in the state of Florida called the Florida Local Government Development Agreement Act, and it sets forth requirements, statutory minimum requirements for a development agreement and the intent for them. The district, according to its land development code and a comp plan on the website, have no provisions that call for a process for a development agreement. I didn't see any process. Section 163.32.20 of the Florida statute states that the intent of a development agreement is to give a developer assurances that upon receipt of a development permit, he or she may proceed in accordance with existing laws. It's important to understand what a development permit is. Under the statute, a development permit includes a building permit, a zoning permit, a subdivision approval, a zoning certificate, special exception, variance, or other official action of the local government having the effect of permitting the development of the land. We're talking site-specific details being approved by the local government through the issuance of a development order. What a development permit does not include is just as important. It does not include a comprehensive plan. It does not include the land development regulations of a government. A development permit does not include a local government vesting upon a developer the maximum potential densities and intensities under a comprehensive plan and land development regulations. At any time, a developer wants to lock in regulations concerning future potential ambiguously described projects that may occur in the next 30 years. A development agreement is intended to go in conjunction with a site-specific development project where the local government knows the specific details about the project and can evaluate that project's merits based on the criteria that are outlined for a development permit such as a building permit or a site plan approval. It appears from the terms of the DA and from what we learned from the prior general counsel and from the agendas of the prior board that there were no pending applications or any just issued development permits for any Disney project at the time the development agreement was being considered and approved. There were no such projects mentioned in the development agreement other than a very generalized description of the project consisting of essentially all lands owned by Disney. Just 2 weeks before the development agreement was approved on the February 8th date, the prior board on January 25th had just approved changes to the land development regulations of the district. Thus, there were no Disney projects that could have obtained a previous development permit for which the new land development regulations adopted on January 25th would have applied. So essentially, you have a development agreement that's vesting maximum densities and intensities on something that hasn't even existed for just 2 weeks without any specific development projects pending for review. In my opinion, the approval of the DA on February 8th, 2023 is in conflict with the intent of the development agreement statute. Specifically, what does the development agreement contain? What does it purport to do? Well, it purports to grant Disney a vested right and ownership and control of the maximum densities and intensities of uses under the comprehensive plan for the entire district, not just for Disney's properties. It appears that the entitlements, maximum entitlements in the comprehensive plan and the land development code for the entire district are the same level of maximum densities and intensities granted to Disney in the development agreement. Thus, a single property owner has ownership of control of the district's entire allocation of densities and intensities and of uses. Further, it purports to let Disney allocate those densities and intensities to whoever it wants and wherever it wants in the district. So it appears as of February 8th, no other property owner in the district can expand or develop their property without buying development rights from Disney. The DA purports to grant Disney the right to sell and assign those maximum densities and intensities to other landowners and ground lessees within the entire district without the district having any say in it. The DA has effectively monetized this district's legislative comprehensive planning authority and land development regulation authority and granted a monopoly to Disney for selling those development rights. There are 0 development right transfer provisions in the comprehensive plan or in the land development code of this district. There is no process contemplated for allowing any property owner to transfer development rights from one property to another property. Thus, the DA is inconsistent with the comprehensive plan and the land development regulations. The development agreement affects the rights of other parties that did not sign it. Further, the DA conveys to Disney interest that the district had in unique and special development rights and privileges and mitigation credits received from the state of Florida and federal agencies. There is not a purchase price associated with the transfer of such rights. There is no valuation provided for those rights. I don't know what they're worth, but they were transferred without any price. They are mentioned in the comprehensive plan, they are mentioned in the land development regulations of this district, and they were assigned to Disney for no value. And with that assignment, it allows Disney alone to use those credits and special privileges obtained from federal and state agencies for its own purposes or to sell those rights to other properties within the district. And it mandates this district to sign off on any permit application submitted to any state agency or federal government whenever Disney wants to use those privileges obtained from state or federal agencies. So apparently we're just supposed to sign permit applications because we're asked to. The district has no right to use those credits, those rights. No other property owners in the district can use those rights. And if the district wanted to use some of those rights, it appears we'd have to pay for them. Further, the DA prohibits the district from regulating the heights of any structure that Disney builds in the entire district. What that DA says that the only restrictions on height are whatever the FAA come up with, which is, pretty unusual for a local government with zoning authority to not regulate height of buildings. The DA further commits the district for a long term at the district's expense to acquire property for design, permit, and construct roads and public utilities for the benefit of Disney properties and projects, and requires the district to buy from and pay Disney fair market value for properties needed to build roads and utilities for those projects. The DA commits the district to borrow and spend money in future years for which bonds have not been secured, taxes have not yet been collected, funds have not yet been appropriated. It takes away this board's and future boards' legislative and budget and appropriation authority and ability to revise its capital improvements program, a function that many governments often update on an annual basis. But for the length of time of the capital improvements program agreed to in the DA, it purports to say that we're not allowed to even change those projects, even if we run into a major financial crisis or a dip in the economy and budget impacts. And also there are things on that capital improvements project that are outside of the control of the district that involve other agencies. So for 30 years, the DA locks Disney into being regulated by the comp plan and the land development regulations that existed on February 8th, 2023. Therefore, that process that I told you was part of your duties here in the next 3 years to review and update your comp plan and your land development regulations, your building codes, and all the similar or related topics involving development of land are all for naught when it comes to Disney, because the DA locks into place those regulations that existed on February 8th. Not only does it lock in the intensities and densities, it states that the process that exists in the code at the time of February 8th is what has to be used. So even if you change the procedures that you use in reviewing development, you supposedly are not allowed to even change the process. Such provisions subvert the enabling act of this district and this board's task given to it by the legislature to review, evaluate, and make revisions to the comprehensive plan and the land development regulations by June 2026. Further, the DA prohibits the district from adopting and enforcing moratoriums on development against Disney. It appears to me that the DA is filled with unlawful delegation of legislative authority to a private party. I've never seen anything like this. The timing, circumstances, and terms of the DA show that the intent of the DA was to circumvent the enabling act of this district and to bind the hands of this board and future boards. So that's the development agreement. The next document,
Go ahead. Yeah.
the next document I found even more unusual. The restrictive covenants that the district approved and signed and were recorded in both Osceola and Orange County. Highly unusual. There is no statute that contemplates a government giving restricted covenants enforceable by others, including other property owners, in the jurisdiction of the government, the authority to regulate the government's actions, to prohibit the government and its government projects from the type of projects it builds, what they look like, and the type of maintenance and operational details highly unusual. There's nothing in the comprehensive plan, nothing in the land development code that contemplate any property owner being able to request from the district a covenant document that binds the hands of future boards. This document is binding in perpetuity against the properties of the district for which were named in that document. There are a lot of them, some of which are the administration building of the district. The district owns its properties for the benefit of all taxpayers, all businesses, all residents of the district, not just for its largest landowner. The restricted covenant states in one of its recitals that it was done because it was reasonably necessary to protect the legitimate business interests of Disney.
Repeat that.
Yes, the last whereas clause, the recital, states in part that the covenant document is reasonably necessary to protect the legitimate business interests of Disney. So, without paying any compensation for this restricted covenant, and I'll back up and say, a lot of folks live in deed-restricted communities. This is very similar to that. This is what this restricted covenant does. It is like a deed restriction on all district properties. So the covenant document doesn't purport to buy or pay anything to the district for these rights that were taken away from the district or given away to Disney. These covenants are enforceable by Disney alone, or its assigns, or its related entities. So what does it do? What does this document do? It's highly unusual. It strips away from the district's properties all potential uses of district-owned properties except those public and governmental purposes on district properties that existed on February 8th, 2023. It requires the district to meet vague standards of workmanship, materials, quality, architectural features, design features, engineering standards, utility standards, and general aesthetic appearance standards, all of which are enforceable by Disney. It imposes property maintenance standards on the district that are enforceable by Disney. It expressly prohibits a whole list of uses that are not government uses, which is obviously intended to protect Disney from competition. It expressly prohibits the district from having on district property any advertising or marketing materials for any other business other than for the district's governmental business. This raises a concern of limitation of government speech and potential limitations of First Amendment rights of private parties that may be in public property. It also prohibits the district from doing any alterations of existing projects or structures or any new projects or structures on those district properties without obtaining Disney's aesthetic and architectural approval. So if the district wants to paint a water tower, water tank, or paint its administrative building, it has to go to Disney for permission to do so. I think this is important to note. The land that we're talking about was not donated by Disney to the district on February 8, 2023, subject to these restrictions. There was no conveyance or closing that happened with these covenants. This was not, okay, you can have this property for free if you keep it for these uses. No, the district already owned these properties. And again, the district owns properties for the benefit of all taxpayers, businesses, and residents. I cannot imagine Orange County, Osceola County, the city of Orlando, or any other Central Florida government allowing or agreeing to allow any private developer or property owner to have this sort of control over a government and the officials that run it. While there were some media reports in late January discussing the district updating its comprehensive plan and land development regulations to address future growth. There were no media reports discussing this development agreement or the restricted covenants and the purpose or motivation behind them. You have to recall at this time that this was going on, the legislature was in special session considering the adoption of House Bill 9B. If that bill would not have been adopted, this district would have been dissolved in June 2023. I think it is important for the district and the public to understand the significance of these documents so this board can decide what to do, whether to investigate further, because you may want to seek remedies to unwind these overreaching agreements that attempt to bind your hands in the hands of future board members.
Does that conclude your report?
Yes.
Thank you for that report. And is there any comments from my fellow board members?
Mr. Chairman. So this is why we're here. This is why this board exists, to provide oversight. And I cannot think of a more naked attempt to circumvent the will of the voters, the will of the legislature, and the will of the governor. This development agreement, which in my opinion is void as a legal nullity, was passed the same day exactly the way you say you're going to build it, including all of the landscaping and all of the public art, and maybe we're contributing to a public boardwalk. These are things that are called incentives, and then the developer gets the right to do something very specific. Did Disney promise to do anything in this development agreement?
I didn't see any specific consideration given.
So the point is that you wouldn't enter into a development agreement unless there was a project, unless you were asking the government for something. Other development agreements that restrict the developer are, for example, I want to rezone a property to commercial because I want to build a car wash. And the city says, okay, that's fine, but we're not just going to give you a commercial zoning because we don't want a storage unit there. So we get a development agreement that says the city's going to rezone the property to commercial so we can build a car wash, but the developer promises and covenants that it'll never be a storage unit. Does this restrict Disney in any way?
It seems like a one-sided agreement to me.
Well, it restricted to the maximum density. It doesn't allow them to exceed the maximum density,
Understood.
which is amazing.
I'm almost off my soapbox. The density rights, this is extremely important. Transferring density rights is a property right. It's just like selling your house, okay? When I do a density right transfer application, I have to provide a purchase and sale agreement between the seller and the buyer. Now, if it's a closely held thing where I'm just transferring it from one guy to the other, it's a $10 consideration, but it's usually for fair market value, bona fide purchaser. And I have to provide that to the city. The seller has to sign an affidavit saying that I am authorized to present this application, that we are authorized to transfer this density. So my question, Kurt and Dan, is it my understanding that this development agreement purports to transfer density rights, property rights off of non-Disney owned properties into Disney's hands?
What it does is it in your comprehensive plan and in your land development code, it establishes ranges for the next 10 years of what maximum densities and intensities can be developed district-wide. What this DA does, it takes and it assigns to Disney the maximum intensities and densities allowed district-wide to just Disney. And it lets Disney control where those densities and intensities can be allocated district-wide, including on Disney's property.
So Disney essentially becomes the planning department for the district.
That's a fair way of saying it.
So we give governmental power to Disney.
That's what it appears, yes.
Okay. Finally, on the general obligation of this taxing district to budget in the future. You know, I've been involved with tourism development contracts, and you know, sometimes we have projects that require funding 3 years, 5 years, but every time I've ever seen a contract from a TDC that says we're going to give this project money, if it's not for that budget year, it says, however, we can give you notice, and at a public hearing, we can tell you we don't have the money anymore. And is there anything like that in here? I mean, this is a general obligation for us to budget into the future.
That I didn't see anything that would give us the subject to budget and appropriation language that you commonly see in agreements that discuss the expenditure of government money for beyond a fiscal year.
Okay, that's all I have on the development agreement. Just real quick on the deed restrictions. You know, deed restrictions, restrictive covenants that I've never seen, and maybe you guys can correct me, I've personally never seen a deed restriction or restrictive covenant on public property. The deed restrictions and restrictive covenants that I see are for the benefit of a city or a county when a developer is redeveloping a property and they want to ensure that you have sufficient setbacks, you have wetland buffers, you have agricultural buffers. I've never seen a county or a city restrict its own property for the benefit of a private developer. Now, it may be something that happens, but it's not something that I have ever seen. So this is extremely unusual in that regard. But the point is that restrictive covenants, again, are meant to restrict a developer to ensure that the development is consistent with the comprehensive plan and compatible with the community. There is no development that's being promised here. It's basically, we've already developed something, now we're going to restrict you for in perpetuity. And I want to read the term of this agreement. Usually when I do a restrictive covenant, for example, for a golf course, we want to redevelop a portion of the golf course, they're going to restrict it so the rest of the golf course has to stay, and there's certain setbacks and those things. You do like a 99-year term. I'm going to read to you the term of this restrictive covenant. This declaration shall continue in effect until 21 years after the death of the last survivor of the descendants of King Charles III, King of England, living as of the date of this declaration. So, I mean, I don't know what else to say. I think these documents are void ab initio. I think they were an extremely aggressive overreach, and I'm very disappointed that they're here. One of the first things I did when I was looking at this board was go on the website, and I noticed that on February 8th, they had an agenda for a meeting, but there were no backup documents on the website. And I saw a development agreement. And one of the first things I asked when I was appointed was, what was this development agreement? And, you know, I'm disappointed to find out what it is.
Thank you for those comments and insight. Any other board members have any comments or questions? Ron?
Yeah, I read the agreement and the restricted covenants on Saturday. Thank you very much, Dan, for providing those. I cannot tell you the level of my disappointment in Disney. I thought so much better of them. This essentially makes Disney the government. This board loses, for practical purposes, the majority of its ability to do anything beyond maintain the roads and maintain basic infrastructure. Now, we're the people's board. We were put in place by the people's legislature that you all voted for. Maybe not everybody did, but we have a process. We have a democratic process, a heavy-handed approach to take these rights away from you and from us and from the legislature is not something that we should sit idly by and permit. Okay, we should be revolted by it. We have a form of government that is of the people. It is we the people. And so, Mr. Chairman, and Kurt, Dan, folks here, the rest of the board, I would encourage you to carefully consider what steps should be taken. We need to restore a basic democracy here, and we need to restore the basic rights so that we have order going forward, so that ultimately everyone, including us, you all, Disney, operate in such a way where we as a nation can be once again what we are called to be. Thank you.
Any other comments from board members?
Yes, thank you. I would just echo what my board members said. I appreciate the overview. I think the reading specifically from the DA and the language that was used is truly underscores the mockery of what the intent of this board was there to do. And so, as was stated before, no private business or no business has any special privileges over another. And that was the purpose of this board, to provide a balance of that oversight. And as was said, it was done in a process that was based on the voters, and this was a follow-up action. So it's disappointing in a couple of ways that this wasn't brought forward also at the new, as soon as we were appointed, because it would have been beneficial to know that, since that action was taken prior to the convening of this board, ultimately with the intent of stripping this board of its authority, which I do strongly encourage that we follow up with investigation and what follow-up action can be taken to unwind this as appropriate. So that would be my request.
Thank you. Any comments? Supervisor Sasso?
I have a question for Mr. Arterman and Mr. Langley. You mentioned that there was a delay, and I know Commissioner Onyx also mentioned that there was a delay in getting these documents. Did that delay create any difficulties or issues for the district that we should be aware of?
I think that's a conversation that's best, attorney-client sort of situation, and not publicly stated. I mean, there's a lot of things that need to be evaluated, including those sort of issues between a legal team, and I think privately that's a discussion I'd rather have rather than publicly.
I understand your answer, and I'll accept it, and thank you for pointing that out. Is there anything else with respect to these agreements that you all found unusual that we haven't talked about that you think we should be aware of?
I think we've laid that out. We've not seen all the documents. The district staff has been sending, there's a lot. I mean, there's a lot of documents. These were the most egregious. We've not really vetted the rest of them, but clearly this came, I mean there's thousands of documents, but these came to us, we looked at them, and that's why one of the reasons we're here.
All right, is there anything else you need from the board at this moment so we can enable you to fulfill this investigation?
Chairman Garcia and I had discussed this Dan, all three of us had discussed it together in quite some detail, and I think the concern was whether our firm alone would be able to handle this if it did result in something beyond just discussions with Disney, assuming that was the board's direction. So on your agenda are special counsel with respect to adding more counsel that could meet Disney's legal team on equal footing if needed. So yes, there is something more I think the board should consider, and that would be considering bringing on additional outstanding legal counsel that has the deeper bench than the Fishback Dominic firm. We have 14 lawyers, including of counsel lawyers, but something like this is pretty extensive, substantial, and will may demand, I should say, a lot of a deeper bench.
And I know we'll get to that. That's next up on the agenda, of course. Mr. Chairman, thank you. I don't have anything further right now. I'll reserve my other comments for later.
Yeah, thank you for the board comments. I have some brief comments here. You know, when I listen to special counsel go through the legal analysis of what happened on the eve of this legislation getting enacted, and then I listen to Supervisor Augst, who is a renowned and in the area of land use, what it looks like to me is that because Disney has the magic kingdom, they thought they could be king for a day. It looks like they were trying to preempt the powers of this board for 30 years on the eve of legislation getting enacted. It looks like they were essentially trying to nullify the act of the Florida legislature, who's there for the people, and the governor. And so let me give you a little perspective of why I agreed to serve on this board. When I was asked to serve on the board, I did a little bit of analysis, and I said, well, it looks like there's really two functions for this board. One is to keep the trains running, okay? And the staff here does a really good job of keeping the trains running. The trains run really well in the district. And so I said, well, I'm not going to contribute much there, and that probably won't require much of my time. But then I read the act, and in addition, it said that this board was to report back to the legislature and the governor's office on how to make this district better, on how this district can function better for all of the people, not just for Disney, but for everybody. Now look, it's indisputable Disney's had a good deal here for 55 years. And if you don't believe me, there's books written about it. There's classes taught in universities on urban planning about what a special deal this was for Disney. And by the way, in 1967, that probably was appropriate. Osceola and Orange counties didn't have a tax base for the infrastructure for this district. So it made sense in 1967 to give Disney special privileges so that this wonderful district could be created. But you know, all good things must come to an end. And if you go back and look at the archives, back when they were drafting this legislation, everybody contemplated that it would sunset at some point in 20 or 30 years. Well, when you have a powerful company with powerful lobbyists, things don't get revealed. And so this lasted for 55 years. Disney had a great deal, and the legislature decided it's time to reevaluate this. It's time to evaluate whether there's a better system for all of the people, not just Disney, for all the people that work and play in the district, for the surrounding citizens in Osceola and Orange County, because the ultimate goal is to make this district better for more people. And so more people can share in the wealth. And that's the function of government, is to make sure that there's a level playing field so that everybody gets their fair share. And so when I saw the function that the board was going to have an opportunity to gather information, hire urban planners, hire other consultants, and report to the legislature on how this district could function better for the people, I said, who wouldn't accept this appointment? Who wouldn't want to be part of such a virtuous process? And then I see that a couple of weeks before we're going to be empowered to benefit the people of Central Florida, the beneficiary for 55 years of this district, Disney, decides they want to be king for a day. Well, our job, as you've heard from my fellow board members, is we're going to have to evaluate those agreements. And if indeed they are as egregious as our lawyers tell us they are, then we're going to take the appropriate action to protect you, the people. And that's what we're here for. Are there any other comments? The only other comment I want to make is when we got these agreements on a late Friday night, Saturday morning, we had to evaluate what we needed to do. And because I've been designated the chairman, doesn't mean I have any more authority than anybody else, worked night and day, literally, with our special counsel. I didn't know special counsel until the day I was appointed to this board, but I knew they were involved in crafting the legislation, and so I recommended to our board that we hire them as special counsel. But they've been acting more than special counsel. I get emails from them at 4:30 in the morning. We talk late on weekend nights, and I have thoroughly enjoyed working with these two lawyers and their firm. They're smart, they're knowledgeable, and they've got great judgment. And so I am grateful for your work, and I know the rest of my board members are. And that's all I've got to say at this point in the agenda. I've got more to say later. Any other comments?